This will be a video 2 for the introductory course for weeks 5 to 6, and this is a continuation of the first video. And in the first video, to recap, we took a quick tour through the 5 sources of legal authority, and then I focused on judicial authority. And we identified that judges are actually lawmakers in our system, that judges make legal rules or create legal rules in 2 ways. Number 1, when they interpret the other sources of legal authority, and then secondly, when they engage in the common law process. And this is where we're picking up, engaging in the common law process. So it seems to me that the first way to go about understanding the common law is to take a look from history. But I want to emphasize that today, and this is February 2021, the common law is still very vital. So when I say we're going to look at history, it's not like we're just looking at some kind of artifact, but something that informs legal disputes and lawsuits today. In any event, we start out in England, and we start out in 1154, and Henry II created a unified system of law, and the way he did that was sending judges from his own central court to hear various disputes. The central court then, I think, may have been in Winchester. But in any event, to hear various disputes throughout the country, and then the judges who were traveling in the realm of litigants, people would bring their legal disputes to the judges. The judges would resolve the disputes. Now, one point to keep in mind is at that period of development in England, there was really no strong legislative body. So it wasn't like the judges, when they were out there deciding cases, had laws passed by a legislature to look at. Also, if you were to look at almost any legal system, even in a primitive form, in the Western world at least, you would see when there are judges and people bringing their disputes to judges, there is a group of people that form, namely attorneys, and attorneys then take on the job, they get paid for it, of representing the litigants, the parties in the legal dispute, the parties in the lawsuit before the judges. Something else that happened, too, was the invention or creation of the printing press, which actually was an adaptation of the wine presses. So the wine came before the books. But in any event, now you've got books, now you've got lawyers, and you've got judges. And at some point, what happens is the decisions of the judges become published in the books. The books are available to the lawyers. The books are available to the judges. And we actually start to see this sort of form of legal research. So now a lawyer is in, I'm going to just call it case B, to give it an identity. And the lawyer argues to the judge in case B, Judge, this case or the legal issue, the dispute in this case is very much like, or is exactly like, an earlier case that a judge 3 years ago decided in another part of the kingdom. And in that case, the judge offered this reason or set of reasons for deciding the case in the way the judge did. And the lawyer continues, he would say it obviously respectfully, you should follow that same set of reasons and reach the same result on the legal issue. There's probably a point of satisfaction that will be achieved if there's consistency in the law. There's a certain value to that. And the judges were inclined to then follow the rules, parentheses, set of reasons, under parentheses, that had been set forth in past cases. So by following the past cases, the judges gave the imprint of the rule of law on the past cases, and there is the common law. And the common law then begins its development. It is modified over time by judges. The common law becomes a feature of the legal system in the United States. And as I noted earlier in this video, and as I put in the posting, it's not just it being the common law is not just some historical artifact, but there are many significant legal rules, such as negligence and contract law, that owe their existence to the common law. And then I'll talk a little bit about what I mean by has never been fully legislated. But let me say this, if this is Sunday. So if you're driving around today on one of the expressways in and out of the city of Buffalo, my guess is you're going to see one or more billboards containing advertising by lawyers. Or if you are watching television, you may run into an ad from one or more law firms soliciting legal business. Now, one of the largest areas for solicitation, in other words, what the lawyers are looking for, what they're advertising for, would be personal injury cases. Car crashes would be an example, vehicular accidents. And so if we just focus on a vehicular accident, the question becomes, what is our legal basis for suing on behalf of someone who was seriously injured in a car accident? And the answer is the tort of negligence. And that was developed at the common law and still largely remains a creature of the common law. We could say the same about contract law. If you're in my contracts course or in someone else's contracts course this semester or in the future, most of the rules that we'll be looking at in terms of what are the rules of contract law are still part of the common law. Now, when I also say have never been fully legislated, what happens is this. Over time, so let's go back to England, you do see the creation of a strong legislative body. In England, that's known as the Parliament, the House of Commons and the House of Lords. Certainly in the United States, from the very beginning, there were legislative bodies. And today, of course, we have legislative bodies at the national level, the Congress, the Senate, and the House of Representatives. In New York State, we have a strong legislative body. When I say strong, meaning that it passes all kinds of laws or amends laws, etc. In New York State, the legislative body is also bicameral, meaning there's two houses. There's the state Senate and the state Assembly. Now, what happens over time is that and it began in England, certainly, and it's continued in this country, the United States. Legislative bodies will, sort of the way I envision it, go into the common law and change it by legislation. So to some extent, the common law has shrunk in size from what it may have been, I'm just going to pick 150 years ago, but it's still vital. But we do see more legislation on rules that once were part of the common law. Okay, now a few points to remember about the common law. In the United States, the common law is state law as opposed to federal law. Now, what do I mean by that? Well, we looked at the 5 sources of legal authority, but we could also do a division. Whatever legal rule we're looking at would be either part of a state law, like the law of the state of New York, or a federal law, which would be in effect everywhere in the United States. The common law rules in each state are state law. And though there's a lot of similarity between the common law, let's say, in the state of New York and the common law in the state of Maryland, there are also some differences. So that's why I say each state can present a slightly different set of common law rules. But we could also say that the common law rules in the different states are not substantially different, and that's why we can use a book, for example, in the contracts course containing largely common law rules, and that book is used in New York State, and that book is used in, let's say, New Mexico. This next paragraph, I just talked about that the legislative branch, anytime it chooses, can eliminate the common law by way of legislation. When the legislature does so, it usually claims at least to be marching under the banner of reform, meaning that it's claiming that it's making the law better. There's 2 significant legislative changes to the common law in New York that occurred in the 1970s, and we'll talk about them later, but they were the no-fault insurance law, which means today to sue somebody for negligence in a vehicular accident, you have to establish that you received a serious injury. Again, we'll talk more about that later. And also comparative negligence, which was a change from what we know as the common law rule of contributory negligence, and again, more of that later. But those were 2 big changes. So now I want to just end with this thought on this video. And this is just about judicial authority in general, so it's not just limited to the common law. Judicial authority, if we stop and think about it, and I referenced this in terms of the Supreme Court of the United States, but we could really just look at the judiciary in general and think that it has the final word on another rule of law coming from another source, because we have that creation of rules by interpretation, and it's also the engine of the common law, which means that we just have a set of judge-made laws. So I can tell you, and I'll say more about this later, but lawyers and paralegals who are involved in representing clients in litigation are regularly researching judicial decisions to determine what the applicable rule of law is. So even if it's a legislative rule, we're going to be looking at how have the judges interpreted it. So what we've been talking about with judicial authority and more in our next 2-week period is something that attorneys and paralegals who are in that area of litigation or related matters are using all the time. I don't think you've got lawyers walking around law offices saying, well, now I'm going to look at the common law, or that now I'm going to look at judicial decisions interpreting, let's say, legislation, but that's precisely what they're doing. And this will end this video. Thank you.